In this video, we're going to review some of the rules that we've learned concerning offer and acceptance under Article 2 of the Uniform Commercial Code. In going over this material in class, we talked about a number of miscellaneous rules, and then we also looked in depth at the Battle of the Forms. I want to start by first going over these miscellaneous rules. I don't want to paraphrase them in great depth. I think it's more useful to look at the actual text of the statutes to see what they say. What I really want to do is just explain what these rules do, and then look at how they might arise in actual cases. The first rule, Section 2205, creates an exception to the general rule that we saw at common law. The general rule is that all promises, including promises to keep an offer open, require some basis for enforcement. Section 2205, however, says that a promise to keep an offer open made by a merchant in a signed writing is enforceable even if it lacks consideration. Section 2206(1) states that unless the offer specifies otherwise, acceptance can be done in any manner and in any medium that is reasonable under the circumstances. Section 2206(2) says that if the offeree attempts to accept by beginning performance, in other words, attempts to accept by making a promise, an implicit promise, by beginning the work, that the offeror may treat the offer as having lapsed if the offeror does not receive notice that the offeree has begun to perform within a reasonable time. Section 2206(1)b is very important. It says that an order for goods will be construed, unless it says otherwise, as an offer. This rule is important because at common law it was always necessary to look very carefully at the actual communication that was sent to determine whether it was an offer or mere preliminary negotiations. We saw an example of that in the Columbus Rolling Mill v. St. Louis Railway case. Under Section 2206(1)b, though, even if the order doesn't say anything else, it'll be construed as an offer to purchase the goods. Moreover, not only will it be construed as an offer, but it'll be construed as an offer inviting acceptance either by a promise to ship the goods or by a prompt or current shipment of the goods itself. And in fact, even if the goods are non-conforming, that too will constitute an acceptance. Section 2104(1) is a very important provision. It essentially says that courts do not need to determine precisely what was the offer and what was the acceptance. So long as the parties can be shown to have made an agreement, whether by words or by conduct, the agreement is enough, even without any specific characterization of one offer and one acceptance. Section 2104(3) loosens the common law rules on definiteness. It says that a promise is sufficiently definite to enforce so long as the evidence shows that the parties intended to make an agreement and there's an appropriate basis for providing a reasonable remedy. Or there's a reasonable basis for providing an appropriate remedy, Now, how do these rules play out in the cases? Well, I think there are really 5 different patterns of argumentation. Let's just go through them one by one. The first pattern involves cases in which the defense is essentially there was no offer. The plaintiff claims the defendant breached the contract, the defense says there was no offer. These rules give the plaintiff 2 different replies. The first reply is that, well, an order for good may be characterized as an offer, so there was an offer. The second reply is, well, in fact, no distinct offer is necessary if the conduct or otherwise the words show the existence of a contract under Section 2104(1). The second pattern of argumentation arises in cases in which the defense is essentially, well, there was an offer, but it was revoked before acceptance. The plaintiff claims that the defendant made a promise and didn't keep it, and the defense says, well, even though I made this promise, I made this offer, it was revoked before you accepted it. The plaintiff says, well, but you promised to keep the offer open. Now, common law, the defense would be, well, there's no consideration for the promise to keep the offer open. But Section 2205 gives the plaintiff a reply, which is that, well, no consideration is needed if the promise is a signed writing by a merchant. Now, of course, in not all instances will all those elements and the other elements in Section 2205 be satisfied. The third pattern of argumentation arises when the defense is essentially that there was no acceptance. The plaintiff says the defendant breached the contract, the defendant says, well, there may have been an offer, but there was no acceptance. Here the plaintiff really has 3 replies. The first reply is simply that, well, the attempted acceptance was made in a manner and medium reasonable under the circumstances. That's Section 2106(1)a. The second reply is that, well, there was a purchase order, and that purchase order invited acceptance either by a prompt or current shipment of the goods or a promise to ship the goods, and that was done here. And the third reply is, well, no acceptance is actually needed if the conduct of the party shows the existence of an acceptance, of a contract, or of an agreement under Section 21041. The fourth pattern of argumentation concerns cases in which the defendant says, well, there is no contract because no notice of acceptance was given. The claim is simply, well, you breached the contract. The defense says, well, there is no contract because you didn't provide notice of your acceptance of my offer before it lapsed, and notice was required because you were attempting to accept by beginning performance. The sixth and final pattern of argumentation is that the agreement is too indefinite to enforce. Again, the plaintiff says, well, you made a promise and didn't keep it, you broke the contract, and the defendant's defense says, well, the agreement is too indefinite to enforce because the obligations of the parties under the agreement are unclear. The plaintiff's reply is, well, the contract is sufficiently definite. It's sufficiently definite because the facts show the parties intended to make a contract and there is a reasonably certain basis for giving an appropriate remedy. Now here, of course, the plaintiff has to specify what that reasonable basis is and what the appropriate remedy would be. Otherwise, the reply is pretty weak. Okay, those are the rules that we talked about, the miscellaneous rules that we talked about, and how they arise in the cases. Let's now talk about the battle of the forms. Here we saw that sometimes parties will form a contract or attempt to form a contract by exchanging forms. In the most typical example, a buyer will send a purchase order form to a seller, and a seller will send back a confirmation and then later ship the goods. The difficulty arises when the purchase order sent by the buyer is not exactly the same as the confirmation sent by the seller. Why should they be? They're often drafted by different people. But really, three questions then arise. The first is there a contract? And then the second question is, well, if there's a contract that was formed by the parties, the forms exchanged by the parties, what are the terms of that contract? And the third is that even if a contract wasn't formed by the forms, if a contract was formed by the conduct of the parties, what are the terms of that contract? Let's start by talking about the issue of, is there a contract? Here we talked about four rules. The first rule, of course, is simply the mirror image rule of the common law. The mirror image rule said that a purported acceptance of an offer is not really an offer, but is a rejection and a counteroffer unless it is a mirror image of the offer. Under the mirror image rule, if the purchase order and the confirmation state different terms, well then the confirmation is not an acceptance, but instead merely a counteroffer. Section 22071's first clause, however, creates an exception to the mirror image rule. It says that in a contract for the sale of goods, a purported acceptance is an acceptance even if it contains additional or different terms. In other words, this section does away with the mirror image rule. However, Section 22071's second clause creates an exception to the exception. It says that if the purported acceptance contains additional and different terms, and if the purported acceptance says that assent to those terms is necessary to form a contract, well then there will be no contract. So the mirror image rule will again apply. However, under Section 22073, even if the writings of the parties do not establish a contract, because of Section 22071's second clause, a contract still could be formed by the conduct of the parties. So, for example, a buyer might send a purchase order to a seller. The seller might send back a confirmation saying, yes, I will ship the goods, provided that you agree to all of these terms, some of which are additional or different. Well, no contract would be formed under the exception to the mirror image rule because of this requirement of express assent to the different or additional terms. However, if the seller then sent the goods and the buyer used the goods, there would be a contract. Okay, well, those are the rules concerning whether there is a contract. Now, how do these rules play out in the cases? Well, again, the plaintiff's claim is, well, there's breach of contract, And the defense would be, well, no contract was formed because the purported acceptance was not a mirror image of the offer. That's the common law rule. The plaintiff's first reply would be, well, a contract may be formed even if the acceptance contains additional or different terms under the exception in section 22071's first clause. The defendant's response might be, well, that exception doesn't apply because the acceptance in this case expressly required the offeror to assent to the different or additional terms, and the offeror to accept the additional or different terms in the acceptance, and the offeror didn't do that. Nonetheless, the plaintiff still has a second reply, which would be, okay, even though a contract was not formed by the writings that were exchanged, a contract was formed by the party's conduct under section 22073. Now, suppose a contract is formed. What are the terms of the contract? Well, let's first talk about what the terms of the contract are if the contract is formed by the exception to the mirror image rule. Here we talked about three subjects. The purported acceptance may contain additional terms, meaning terms which are not in contradiction to anything that's in the offer, but are additional terms. So, for example, the acceptance might say that all disputes will be arbitrated when, in fact, the offer doesn't say anything about the subject. How are additional terms in the acceptance treated? Well, the general rule is that additional terms are construed merely as proposals for addition to the contract. They become part of the contract only if the offeror agrees to them. However, there is a merchant rule in section 22072's second sentence which says that additional terms become part of the contract unless the offeror objects to them, either in advance or after seeing them, or unless they materially alter the contract. This requirement that they not materially alter the contract generally means that the merchant rule won't apply. In most instances, anything that the parties would consider worthy of arguing about will be something that materially alters the contract. Now, what about different terms? Suppose the offer says one thing and the acceptance directly contradicts it. The offer, for example, says that performance has to be done in 10 days, and the acceptance says that performance will be done in 15 days. What is the term of the contract? Well, unfortunately, section 2207 doesn't address different terms. It's something that the drafters apparently overlooked. There are three schools of thought on how to deal with different terms in an acceptance. One school of thought, based on comment 3 to section 2207, is to treat them just like additional terms. Treat them as proposals for modifying the contract, and say that they become part of the contract if the two parties are merchants unless they materially alter the contract. Another school of thought is, well, because section 2207 doesn't say that you're supposed to do anything with the different terms, just ignore them and say, well, the terms in the offer control. That's the argument that's presented in our casebook by Professor Summers. The third approach, an approach which is the most common but is also a very controversial approach, is the knockout approach. The knockout approach, which is based on comment number 6 to section 2207 and advocated by Professor White, says that if the offer and the acceptance contain different terms, 10 days for performance and 15 days for performance, those two terms then knock each other out. They simply cancel each other out, and the contract is silent as to the time of performance. Well, what do you do if the contract is silent on an issue like the time of performance? Well, the UCC contains many provisions which are often called gap fillers. Gap fillers are provisions that specify a rule if the contract does not. For example, section 23091 says that if the parties don't specify when the contract is to be performed, it is to be performed within a reasonable time. And so if the term is knocked out, well, then the gap filler applies. Now, how do all these different rules apply in an actual case? Well, let's suppose that the plaintiff says that the defendant broke a promise to do X, where X is some term of the contract. And the defendant's defense is, well, I didn't promise to do X in my offer. Plaintiff's first reply might be, well, the term X was included in my acceptance, and it became part of the contract under the merchant rule in section 22072's second sentence. The plaintiff's response to that argument might be, well, the merchant rule in section 22072's second sentence does not apply because its elements are not satisfied. For example, it would work a material change, or we are not merchants. Accordingly, the plaintiff would say, at most, the term is a proposal for modifying the contract, which I didn't accept, and therefore it's not part of the contract. The plaintiff, however, also has a second reply, which is that, well, the term X is part of the contract as a gap filler, either because the agreement didn't say anything about X, or because the offer and acceptance stated different terms, or different. The terms were different on that particular issue, the issue covered by X, and therefore they were knocked out, and the gap filler applies. Now, of course, for the term to become part of the contract as a gap filler, you have to find it somewhere in the UCC, either in Section 2309 or in some other provision of the UCC. The defendant's response is, well, the court should not apply the knockout approach if that's what you're relying on. It should either say that the offer controls or should treat the different terms, if that is what X is, as additional terms. All right, the last question that we talked about are, what are the terms of a contract formed by conduct? Here, Section 2207 is much more specific. Section 2207(3)'s second sentence says that the terms of the contract are the terms upon which the writings agree, plus any additional terms, any gap fillers supplied by the UCC. Again, of which Section 2309(1) would be an example. Again, these rules apply if the writings of the parties do not establish a contract, but the conduct of the parties does. Now, how would these rules apply in an actual case? Well, the plaintiff would say that the defendant broke a promise to do X. The defense would be, well, our contract was formed by conduct, and X is not a term on which the writings agree. Therefore, it's not part of the contract, because Section 2207(3) says it includes only those terms upon which the contract agrees, but the reply might be, yes, but it also includes gap fillers, such as Section 2309(1). We saw an example of this in the Dighton v. Penwalt case. Dighton v. Penwalt said that the plaintiff argued in that case that there should be a 4-year period of limitation, either because a contract was formed by conduct and it applied as a gap filler, or if a contract was formed by the forms, the knockout approach should apply, and it again should apply as a gap filler. Those are the various rules that we've seen concerning